Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching.
In this video, we will consider a case study related to the designation of Francesca Albanese to the US blocking sanctions. And the reason why I chose this specific designation for the purpose of the case study in our series, Sanctions 360, is that this seems to be an unprecedented situation when a person was designated solely for her speech. And it's an important case for our series because it shows the circumstances which presumably none of us would expect to lead to this kind of measures being taken against an individual by the most powerful state in the world, and the drastic consequences which such designations can have on the individual. And more specifically, we would look in this presentation into the following points. We would first discuss the factual background to the matter. Then we would discuss the justification given for this designation, as well as the unique nature of the case. We would briefly summarize the legal argument as it goes through the US courts, and then we would finalize this presentation by looking at the individual and personal effects of this designation. So by way of summary, the US President Trump issued beginning 2025 the second executive order with respect to the International Criminal Court. In essence, the US administration is in disagreement with the jurisdiction which this court can potentially enjoy with respect to the US officials, and in connection with this order also with the respect to the officials of the US allies. And they have repeatedly mentioned that they would take very restrictive measures to prevent even the possibility of these things occurring. So the executive order issued by President Trump, in essence, provides that people who assist the International Criminal Court in connection with the investigation of crimes, which this court has jurisdiction to investigate with respect to the US officials or the allies of the United States, may be subject to the US blocking sanctions. And the US blocking sanctions, in their turn, mean that, in the first place, all property and interest in property, a notion which is defined extremely broadly, covering all types of assets of these persons within the United States, will be blocked, and no kind of operations with that property will be permitted. And this type of restriction implies that, in addition to blocking of property as such, this person cannot receive any funds, goods, or services from or provide to any person within the United States. So that's the territorial effect of this type of restriction. And as we can see, they are, in essence, extremely broad, and, to summarize, prohibit for any US citizen to provide anything of value, regardless of how small this value is, to the designated person. The sanctions are very severe for the breach of the relevant restrictions and can result in both civil liabilities and criminal liabilities, going as far as 20 years imprisonment. So that's a very, very severe type of restriction, coupled with very severe penalties. Important, though, is that because the risk of designation applies to any person dealing with the designated person, then, in addition to the territorial effect, these relevant sanctions would also have the extraterritorial effect, as many institutions outside of the United States would be afraid of dealing with this person for fear of their own designation. Ms Albanese is someone who would commonly not be expected to run the risk of being designated to the US blocking sanctions, which we would normally expect to be applied to terrorists, people responsible for grave human rights violations, responsible for war crimes, or indeed severely undermining the US national security. Conversely, Ms. Albanese is a scholar, primarily focusing on matters of human rights and Israeli-Palestinian conflict. In addition to this, she is appointed by the United Nations as the special rapporteur in Palestine, and in her role, both as a scholar and as a special rapporteur, he was highly critical, in the view of the US government, biased towards the position of the Israeli government and its allies, US in the first place, in this conflict. Important to note that Ms. Albanese has no formal role within the International Criminal Court, which the executive order purports to target in the first place, except that there is a broad memorandum of cooperation signed between the United Nations and International Criminal Court, which in essence says that they would cooperate together with respect to the areas of common interests, namely bringing the end impunity for those crimes which the International Criminal Court has jurisdiction over. Having said that, certainly in no way the reports of Ms. Albanese trigger any legal obligations on the side of International Criminal Court, and this has never been alleged by the US administration. In July 2025, Secretary of State Rubio decided to designate Ms. Albanese under the Executive Order 14203, and he justified his decision on the following facts. He mentioned that Ms. Albanese is directly engaged with the ICC in its efforts to investigate the nationals of the United States and Israel in connection with the alleged crimes perpetrated in territory of Palestine, including issued recommendations to the court to issue arrest warrants targeting the high officials of Israel. Then she wrote letters to various corporations and companies accusing them of crimes perpetrated within the territory of Israel in connection with the support they provide for the settlers in the Palestinian territories, as well as made some other remarks in this rather, I would say, emotionally drafted statement against Ms. Albanese and her scholarship, as well as general attitude towards the conflict. Whatever one might think about the views of Ms. Albanese on the point, and certainly here people would disagree on the matter, which is quite obvious given the sensitivity of the issue. An important point for us as the sanctions scholars is that Secretary Rubio, in the summary of the facts leading towards Ms. Albanese's designation, did not mention anything which is not speech. And in this sense, that's a very unique designation, because whatever one might think about the views of a person, one cannot arguably deny that it would not be justified to impose one of the harshest times of restrictions against these persons based on her or his speech only. And this is exactly what happened in this case. There's no reports whatsoever that Ms. Albanese was able to take any kind of formal actions in connection with the prosecution. This has never been mentioned by the US administration, neither in this original statement of Secretary Rubio or in the following proceedings in the US court. So the unique peculiarity of this case is that the person was designated to the US blocking sanctions, in summary, solely for the reason of expressing the view which the current US administration does not share, which certainly makes this case remarkable in its own way. Ms Albanese, or rather her relatives, tried to challenge and are in the process of challenging this designation in the US courts. They filed the motion for a preliminary injunction with the US District Court, which was granted in the first place and then reversed on appeal by the US administration. The argument in the US court is largely focused on the First Amendment rights of Ms. Albanese, the argument being that if she was exercising her First Amendment rights and was designated because of those rights being in effect, then this designation is certainly illegal on the basis that it restricts her constitutional rights. The argument goes down to a rather technical question of whether non-citizen, as Ms. Albanese is just an Italian citizen, largely speaking outside of the United States, may be entitled to the First Amendment rights, which the administration says she does not. And on the Ms. Albanese side, the argument is that over her life, she established very deep connections with the United States for the reason of being regularly present and speaking at various US universities, being the rapporteur of the United Nations, having a child who is an American citizen, having property in the United States, and in part her speech occurred within the territory of the United States as it contained in the report submitted to the UN Secretary General. So ultimately the question revolves around those technical issues regarding the scope of the First Amendment rights, and it's largely outside of the scope of this discussion, given that the focus is on sanctions. What's important for us to take from the case are very severe restrictions, which an individual, even of this type of public profile, faces in case the US decide to impose the blocking sanctions. By way of example, Ms. Albanese faces both professional, personal repercussions, as well as those negative repercussions are also to an extent applicable to her immediate family members, although none of them is designated in his or her own name. Ms. Albanese can no longer enter the US territory. Certainly her engagements with the commercial and public bodies within the United States, including the US universities, were severed. She's denied access to the US banking system. All the accounts are blocked. She cannot receive any payments in connection with the insurance claims. She has no access to her property within the United States. And although OFAC issued some limited licenses, permitting the upkeep of the properties, as it often happens, the license is not broad enough. And although it's issued, does not permit them, be not the US persons, to take care of the property themselves. Important to note that those restrictions apply not just to Ms. Albanese, but to her immediate family members. That's how the executive order is drafted and operates. Her husband, who was the employee of the World Bank, can equally no longer enter the United States, as the restriction applies to him, being a close family member of Ms. Albanese. Certainly that had an adverse effect on his career. The property which he owned with his spouse cannot be managed by him as well as he cannot sell the property, because to the extent the sale occurs, the proceeds have to be blocked in a US account and is not available to him. So he faces equally quite substantial restrictions on that matter. And most interestingly, because the couple has a child who is a US citizen, this child, being a US citizen, is subject to the same type of restrictions which we discussed at the beginning of the presentation. Namely, she cannot provide anything of value to her mother because that person is a designated person, except if specifically authorized by OFAC, which is not the case. And in case she does it, she faces the potentially criminal prosecution at the level which we've discussed. And the definition of anything of value is what it is. There is no de minimis permitted payment. So, for example, any kind of gift which she would like to give to her mother, for example, for Christmas or for birthday or on any other occasion, potentially and formally is qualified as a breach of the US sanctions with the penalties we've just discussed. A different question whether this would really be enforced, but the fact that the law, which is effective, is not enforced, frankly, is of very little comfort to the person which is potentially in breach of law. On top of this, all these restrictions are of indefinite duration, and it's in essence up to the political decision of the administration, which at the moment is clearly not present, to decide when and if they will ever be taken away. In summary, we found it useful to discuss this case in the series, both on the basis of the case being really exceptional, for the fact that the person is penalized for what is just speech, and to demonstrate the really severe effect that the US blocking sanctions can have on the individuals, certainly within the United States, but also outside of the country, given the potential risk of those persons dealing outside of the United States with a designated person becoming designated persons themselves. Thank you very much for watching. I trust you found this presentation useful, and I hope to see you during my next presentations.